Hello, chat. Let's start this deep dive into the Afroman case. Trial is set to start next week. On the docket, I see the 17th as the first date, but I think jury selection might start on the 16th. Who knows? I know the big question is going to be, can we watch it? I don't know if there's going to be cameras in the courtroom quite yet, but of course, if there are, I will make sure that's top priority. I want to watch every second of it. And if not, we will read whatever coverage we can find to see what's going on. We're going to be going through a few motions. We're going to look at the initial, or not the initial, the most recent complaint. So there was a first amended complaint to see what the plaintiffs are arguing. Two of their claims have already been dismissed, so they won't proceed to trial. And we're going to work our way up to what's on the screen now, which was recently filed. The plaintiffs want to exclude some of the evidence that the defense, Afroman, had just sent in notice saying that he intends to try to produce at trial. So we're going to work our way up. If you want to look at documents in this case, there's a link in the description. You go to adamscountycourts.com, you go to the record search option, and then you can search. You have to do it by last name, comma, first name, and Afroman's full name is Foreman, comma, Joseph. And then you can just hit your search. You'll want to find this specific case, which is going to be this down here, the civil injunction, case number ending in 69. And you can click on this docket and you'll be able to see all of the activity, most recent stuff at the top. So there you go, in case you've wanted to look at this on your own and look at some of the stuff we won't look at today. There's how to do it. And let's get started with the first amended complaint. The reason this is so important is because the motion in limine, if you couldn't tell from the thumbnail and the title, the plaintiffs, so Shawn, Cooley et al., the officers, they want the judge to grant their motion in limine to exclude the lemon pound cake video. They're arguing that not only is it not relevant, but that there's nothing relevant about that video that could go towards Afroman having a defense against any of their claims, any sort of defense against any of their claims. I think it's important for us to read the complaint because I think lemon pound cake is a critical part of this lawsuit. So let's take a little time travel. We're going back to May 10th of 2023. This is in front of Judge Jerry McBride. It's their first amended and supplemental complaint for damages and injunctive relief, with jury demand endorsed hereon. So as we go through this, the first two claims, claims 1 and 2, when we get there, those have since been dismissed, right? So those are not going to be on the table at this trial. So for the first amended and supplemental complaint against Joseph Edgar Foreman, aka Afroman, Hungry Hustler, Media Access, John Doe 1, John Doe 2, and John Doe 3, plaintiff Shawn D. Cooley, Justin Cooley, Michael Estep, Shawn S. Grooms, Brian Newland, Lisa Phillips, and Randolph L. Walters Jr. state as follows. They're going to go through, but just so we know, Cooley is a deputy. Shawn Cooley is a deputy, or he has been at all relevant times with the Adams County Sheriff's Office. Justin Cooley, deputy with the Adams County Sheriff's Office. Michael Estep is a sergeant with the Adams County Sheriff's Office. Shawn D. Grooms, deputy with the Adams County Sheriff's Office. Brian Newland, detective sergeant. Lisa Phillips is a deputy. Randolph Walters is a sergeant. And then they're going to say Joseph Edgar Foreman, aka Afroman, is an individual that resides in the same county, in Adams County, Ohio. So defendant Hungry Hustler Records on Information and Belief is a business entity doing business in and with its principal place of business in Adams County. We're gonna skip some of this stuff. They're just saying why we're doing this filing in this jurisdiction. Let's get into the factual background. And again, when you see factual background, it's not saying that this has been 100% fact the way we would use the word fact colloquially. It's what we're alleging and say that we want to be able to prove against the other party. So factual background, Afroman products and merchandise. Defendant Joseph Edgar Foreman is a creator, producer, and performer of music and videos who's known by the stage and commercial name Afroman. In addition to music and music videos, Foreman markets and sells a variety of products under the trade name Afroman. These products include beer, marijuana, t-shirts, and other merchandise. Foreman sells his Afroman products online and at live events at which he performs. Now we're going to get into, and again, this is filed by the plaintiffs, the officers, the search of defendant Foreman's residence. This is how they're framing it. On or about August 21st, 2022, law enforcement officials from the Adams County Sheriff's Office conducted a search of Foreman's Adams County residence pursuant to a lawfully issued search warrant. Foreman was not present at the time of the search, but his wife was in the home, observed the search, and recorded portions of the search on her camera phone, including the faces and bodies of many of the law enforcement officers involved. Now, I would say this is making the lemon pound cake video relevant because it would show the wife in the home doing this stuff. If there's any reason to contest any of this or to corroborate it, that video is relevant because it's footage of this. So, Foreman's residence was equipped with several security video cameras, which also recorded many portions of the search, including the faces and bodies of many of the law enforcement officers involved. Next, we have Foreman creates commercial videos with faces and bodies of plaintiffs. After the search was concluded, Foreman used portions of the recordings of the search from his wife's phone and his surveillance cameras to create music videos about the search. These music videos, so they're arguing about these music videos, clearly portray the images, likeness, and distinctive appearances or personas of many of the officers involved in the search, including those of all plaintiffs. Foreman created dozens of videos and images of plaintiffs' personas and posted them on various social media platforms, including Facebook, YouTube, Snapchat, TikTok with a C, and Instagram. What's TikTok with a C? Thousands of people have viewed Foreman's postings. It might be more than thousands now. It might be more than thousands now. And I would imagine this lawsuit probably brought in more views. Foreman has used and continued to use the videos and photos of the plaintiff's personas for commercial purposes, to promote his Afroman brand, to sell products, to promote his music tours, and to make money from the use of plaintiff's images on videos and other media. Following are only some of the many examples of the defendant's use of the personas of plaintiffs for commercial purposes. Instagram post containing an image of Foreman wearing a shirt with an image of plaintiff Shawn Cooley beside an image of Peter Griffin from Family Guy. Caption says, "Good morning, ladies. What up, fellas? Congratulations to Police Officer Pound Cake. Thank you for getting me 5.4 million hits on TikTok with a K. I couldn't have done it without you, obviously. Congratulations. Again, you're famous for all the wrong reasons. As you can see, all my pound cake is gone. Officer Pound Cake confiscated my pound cake. He said something happened to his body camera on the way to the evidence room, LOL." And then there's links. I'm not going to try to copy and paste it, but if you want to go find this post easily, you can go to his Instagram page or get the link from this filing. Instagram post B. Instagram post containing images of fans holding merchandise that contains images of Shawn Cooley. Caption, "Lemon pound cake," with 3 exclamation marks. C. Instagram post in which Foreman confirms that OG Afroman, that's his handle, is his official account. Post contains images of plaintiff Brian Newland, then advertises Afroman's new album. D. Instagram post containing images of Foreman wearing a shirt with images of plaintiff Justin Cooley. Post promotes new album. Caption, "What's your favorite song on Lemon Pound Cake so far? Also, what's your favorite line?" E. Instagram post containing image of Foreman wearing merchandise and promoting merchandise with images of plaintiff Shawn Cooley. Caption, "I am pressing up merchandise for my up-and-coming Canada tour. Which Officer Pound Cake shirt do you like the most? The one on the right or the left? Let me know so I invest my money in the more popular shirt." F. We have Instagram posts containing images of merchandise. Some of the merchandise contains images of plaintiff Shawn Cooley. Caption, "Canada, get ready for the most hunted to, most wanter, the most blunted rapper in the world. For the first time, I will have brand new merchandise available on the month-long Canada tour. Bring in merchandise money. I will sign everything that is bought. T-shirts, $35. Hoodies, $70. Beanies, $30. Instagram post containing video of fans and defendant singing Lemon Pound Cake while a fan wears merchandise that contains images of plaintiff Shawn Cooley. Interview on Vlad TV during which Foreman discusses the use of the search as material for songs. Foreman admits to using images and clips from the search in videos and promotion. So again, we're going to jump forward when we get to this new filing. They're going to say that this music video shouldn't be admissible because it's not relevant to the claims and it's not relevant to any possible defense that Foreman could raise against those claims. But they're saying Foreman admits using images and clips from these search videos that were used in this music video. Foreman states that his, quote, "Will you repair my door" song, which there's also a motion in limine about, went viral. Foreman states that his lemon pound cake clip went viral on TikTok. Foreman says, "Everybody understood what I was talking about when I said lemon pound cake. That's the cop on the viral video, TikTok, that was going through the house that wanted a slice of lemon pound cake." And then includes image of plaintiff Shawn Cooley on video. So they're like citing here to a portion of this Vlad TV interview where they show this video within the Vlad TV interview. But it's not relevant. Instagram post that portrays plaintiff Shawn grooms next to an image of Quasimodo, the Hunchback of Notre Dame. Caption, "Good morning, ladies. The hatchback," it says hatchback. "The hatchback of Adams, KKK County, said to get my new album Lemon Pound Cake September 30th. Instagram post that portrays, and is this really using likeness? This is satirical parody. So, Instagram post that portrays Judge Gabbert, the judge who signed the search warrant, next to an image of Droopy. Caption, "This is the judge that signed the warrant that said kidnapping. His name is Roy Droopy Gabbert. Vote him out before he signs a fictitious warrant, then sends some overreacting paranoid cops with KKK spelling to your house, jeopardizing the lives of you and your family, stealing your money, and disconnecting your home video security surveillance system. Vote out Judge Roy Droopy Gabbert. Then go get my new album Pound Cake. September 30th on all platforms." Okay, Instagram post that portrays plaintiff Lisa Phillips next to an image of the Mona Lisa. Caption, "Good morning, ladies. Here she is. The condescending," and he censored the "you," but it's cunt. "Adams, KKK County, Sheriff with one F, Lieutenant Mona Lickum Lolisa." To serve and disconnect ... your home video security surveillance system, so you won't have proof that the Adams County Sheriff Department's stealing money and other things around your house, even possibly planting false kidnapping evidence. I used to speak to this lady when I dropped my kids off to school. I always wondered why she never spoke back. Just looked at me with the same condescending cunt look you see in the picture. He's censoring the C word with a question mark. Unless maybe he's using an emoji and it transferred over as a question mark. "I spoke to her again at the metal detector in the Adams County Courthouse. Her voice was 3 octaves lower than mine, LOL. Has anybody in Adams County verified her vagina? What are we doing? What are we doing? If you haven't, you should, or she might whip out something bigger than yours. If this lady is your friend, I wouldn't leave her alone in my house. Or I'll put it this way, if you leave and your video system is messed up when you get back, you know who did it. Why would a good cop want to disconnect a video security surveillance system? Lieutenant Lickum Lolisa, question mark. New album Lemon Pound Cake dropping September 30th. My name for this particular officer is Lieutenant Mona Lickum Lolisa. What nickname did you come up with for her? I'm good, but I will admit yours might be better than mine. What you got?" What are the comments on that Instagram post? Chat, feel free to participate, even though this is a request to the Instagram, if you want to come up with some names. We might not be well acquainted with Lieutenant Mona Lickum Lolisa, but I'm thinking of Lisa a lot. So, Credits and Mikey, good to see you. Jumping on in here saying, lemon pound cake. You guys know I love hanging over. I sent you guys over to Credence and Mikey's channels yesterday. Let me drop a link real quick. Because if you like watching, well, I guess since it's body cam footage, you don't always see the officer. But if you like watching police on video and or video from their perspective, he does a lot of body cam watches. So perfect channel to drop in the chat right now. There is a channel link. Go hang out with Mikey. Also lots of car chases. So there you go. We've got, let's add me reading this to the cat clips. Yeah, we're after 5. It's after 5 p.m., so this is perfect timing, you know? Good timing. We've got, let's see. We've got next one, YouTube videos depicting most or all of the officers involved in the search, set to music and used by Foreman to promote his brand and sell his products. And then there's 2 video links there. I wonder, this isn't going to let me like copy and paste. Why is it? This is stupid. Let's see if it just lets me paste. No, I don't know what video. Let me do a text extraction because I'm too lazy to try to type out like the 10 letters that are at the end of the chain of this. But my little clip screenshot snipping tool lets me do quick. Yes, it worked. Okay, text extraction. This first video. It says this video isn't available anymore. Okay, this one, let me get my tabs in order. All right, this one looks like, let's see. Afroman, why are you disconnecting my video camera? And it's an official video. I don't know if this is like a music video. Let's just scrub through a little bit. I'm going to drop this link in the chat. And I'm also going to add it to... See, I've got all these playlists. I got my creator friends. So I just put AV in there today. AV to the 7th power. Just put Classy in there. Just put Take It to Trial in there. Put Nick Starro in there today. Nick Starro did a panel with JD Law Explains and Mo on the Corey Richens case. So check that out. I'm also going to add Fit Lawyer and Jay Witt. They're going live later. I'll have to throw Mikey in there the next time I see him live. He's got a few in that list already. I'm going to plop this right in the Afroman trial playlist, which is linked in the description if you want an easy way to get to this video later. So let's just scrub through. Oh, I don't want that. I don't want Afroman coming at me. I don't want a nickname. I don't want an unendearing nickname. So yeah, this is like they're coming through the gate. I believe they broke this gate. If this is from his property, they broke this gate upon entry to drive through it. Jeez. Like, what are they doing? Hold on, let's... we watch that little bit? Oh wait, that's the Family Guy shirt, chat! Hold on, wait, here's the Peter Griffin shirt. You see it? You see Peter Griffin over here? That's what I wanted to look for. This is moving too fast. I'm gonna have to slow it down. I'll slow this down so I can show you guys the pound cake. Right there, right? Is that the lemon pound cake? There we go. There we go. This is totally relevant. We've got Mary Kay. We've also got a Mary Kay box here, it looks like. This is crazy. What are we doing? This is crazy. I would be so pissed. I would be more pissed if I wasn't home when this happened, but, like, a family member was home. Like, what the heck? This is a nice closet. This is fun. Why does his face look like this? Okay, they're putting emojis over the family. That's respectable. The kids aren't visible. So shout out to that. Like, this isn't malicious. This isn't, like, trying to harass the kids. Let's see. Affidavit. This is a search warrant. All right, let's see if we can read a little bit of this. It says, yeah, the kidnapping's right here. Concealed in violation, possession of drugs, trafficking, and kidnapping. Shoe collection. Going through his CD collection. You're so interested in his music and his stuff, but now you're mad that you're in it? Come on. What are they doing here? It sounds like he's going, go, go, go! So, does this mean that they wouldn't even have had this surveillance footage if it wasn't something that uploaded in real time? Like, because some camera feeds, like, go right to a cloud server. So even if you disconnect it, you still have a way to access the data. But if this had just been, like, a hard copy, Is this something that they might have confiscated and this footage might not be readily available to Afroman? Like maybe he'd have to request to get it and they'd have to be like, yeah, we'll provide it to you if you fight for it. If we even say that we actually have it. I think that's probably the case. That this is probably going to cloud storage and that's the only reason he was able to grab this right away. Because they're sitting there disconnecting it. Like, that's crazy. Look at this nugget. You ever open a box of chicken nuggets and like one nugget is almost perfectly round? Like his head doesn't even have a neck. They purposely, the way he's crawling through this house, it's like he knows he shouldn't be there. Oh man. He's in the fridge! Why are you in the fridge? This is the guy that's looking for the lemon pound cake, isn't it? Is he gonna open the... This is not funny, but this is funny. Oh, man. Yeah, okay, so yep, they're calling him Lemon Pound Cake guy. Look at it. Okay, there he is looking at the cake. Is this... Oh, I know it is so funny though, but I feel bad. This is frustrating and annoying. And I absolutely do not blame anybody for making this into something that brings some levity. And also a lot of attention to what they're doing. You know, it's two things happening. Oh, a better version of the shirt. I gotta get one of these. Is there a link in the description? I'm gonna order one right now while I'm talking about this lawsuit. Let's see. Let me make sure I like this. This is crazy. Awesome, awesome closet. Love it. Alright, I think this might just be... Okay, wait, here's a little bit more. Alright, what is this? Oh my. Okay, this is wild. Alright, let's watch this little bit. Just busting in there. First of all, this doesn't look like a safe approach. I'm not law enforcement. Was that a safe little maneuver? I don't know. Surprised they didn't get caught in the curtain and start freaking out. Like that one officer that shot because they saw their own reflection in the mirror. I don't know if you guys remember hearing about that one. Oh, that's fun. God, they're gonna add... If they press charges, they probably would have been like, the color green, slime green. What a mask collection. Look, he's got all the teams and stuff. He's just pretending he's hiding under stuff and they can't find him. This is glorious. Look at this. This is art. Oh man, you guys. You get it. I'm gonna go get a shirt. I have to get one of those shirts. Maybe I'll look at the other shirts and it won't be that one, but that one's looking pretty good. I will wear it next time we do a stream if I get it in time on this case. All right, so back to the things. The things, actual filings. That was a long detour, but hilarious. So we've got, yeah, so I think it was a lady cop, I forget, but if you search like on YouTube for cop shoots reflection, you'll see the body cam footage. She like screams and she like, or he, I don't remember, but they like warn that they see somebody and immediately start shooting, but it's their own reflection. Mr. Cake guy. He looks like a lemon pound cake. Oh man. Gosh, what a time. Anyway, so then they say defendant Foreman created many other videos. I mean, the people want it. Posted on various social media platforms that use the personas of each of the plaintiffs for commercial purposes. That is, to promote his live performances, his music, his other merchandise, and his Afroman brand. Well, you know what's interesting is, like, Is Family Guy upset that Peter Griffin is on these things? Like, doesn't seem like they have a lawsuit about any of this. But the officers with hurt feelings are thinking that this is inappropriate when I think they have less standing than like a trademarked show. Anyway, after the complaint of this action was filed, because remember, we're reading the amended complaint, Foreman continued and intensified his efforts to use plaintiff's persona for his own personal gain. A few examples follow. Photo with Shawn Cooley image on merchandise with caption, "Order your t-shirt now," with ogafroman.com. Okay, wait, so I'm gonna share that one in the chat. Well, let me make sure it's actually still the live, like where you can go. OG Afroman, since this was 2023, I mean, I doubt he changed that domain, but all right, yep, that is still live. Let me drop that link in the chat. I'm assuming this might be the place to go find a t-shirt, maybe. I'll have to look after stream and get going on that. Ah! Chat! Friday, January 30th. Oh, that's past. But Saturday, April 11th, that's less than a month from now, he will be in Florida. Oh, man. I gotta get a shirt. I gotta go. Okay, so they're saying, order your t-shirt now, ogafroman.com. Order the new album and lemon pound cake on all platforms. Thank you for your support. Photo with Lisa Phillips image on merchandise with caption, "Order your Lieutenant Lickum Low Lisa full of shit Phillips t-shirt from ogafroman.com. See what the fuss is about. Get that new album called Lemon Pound Cake, available on all platforms by Afroman." Photo with Randall Walker's image on merchandise with caption, "Order your Ranger Randy Private Pile Beatty Bailey Walters t-shirt now at ogafroman.com. A portion of proceeds will go to police reform and fighting social injustice." Oh, no. Video of image of merchandise with Shawn Cooley's image with caption, "Thank you for all the support on the merch. We sold so many shirts that we had to order more, but trust your orders are on the way. New shirts about to be available in the merch store, so stay tuned." Photo, yeah, we gotta do Boca Bash with Afroman. We gotta be fully decked out. Yeah, same thing. Gwennon says, "Cops are giving him more publicity. I'd forgotten all about Afroman." Yep. I forgot. I remember seeing this be newsworthy years ago and forgot about it until, I think it was Tina that said in a stream a few days, on Friday last week, I think. A week ago. I was like, are you watching that trial? You're covering that trial? And I'm like, what? That's going to trial. And we had to go through. I couldn't believe it. Couldn't believe it. And here we all are paying attention. So, we've got photo with Randall Walker's image on merchandise with caption, "Good morning, ladies. Pre-order your baby making Brian Newborn Newland t-shirts now." So that must be one of the guys that looked like a baby. "New police officer pound cake shirts are in. Let's go. Order your Lieutenant Lickum Low Lisa full of S. Phillips t-shirts from OG Afroman and see what the fuss is about. Get that new album called Lemon Pound Cake, available on all platforms by Afroman." So then they say Foreman created, performed, posted, and publicized these and other depictions of plaintiff's persona for commercial purposes without the authorization of any of the plaintiffs to do so. Plaintiff's personas have significant commercial value. I think Foreman gave your personas value, or his parodies of your personas. Plaintiff's personas have significant commercial value on their own, like before, which Foreman and the other defendants are unlawfully exploiting for their own financial gain. So, Foreman created, performed, posted, and publicized these and other depictions of plaintiffs' personas for commercial purposes through, in cooperation with, or with the assistance of the other defendants, all of whom knew that the use of plaintiffs' images and identifying characteristics was not authorized by plaintiffs. And see, that's my gripe with this, is I don't think the direct issue here is, oh, you're using my likeness. It's, no, you're exposing what we're doing, and you're disguising it under this claim. So, Reed says, I was following it up until the time Bruce Rivers went for the pound cake and milk and never came back. He just commented last week on one of Afroman's posts, like wishing him luck in the trial. It was a nice comment. We've got Foreman defames plaintiff with false statements. So we're going to get into more of the other claims. In addition to and in connection with his use of plaintiff's personas for his own personal profit without plaintiff's permission, Foreman published false and defamatory information about plaintiffs, which he knew to be false, in a malicious... Which he knew to be false. And you're going to argue this week, in this motion in limine, that you should exclude the video because it couldn't in any possible way go towards any possible defense Afroman might raise against your claim, like this one, that he knew this to be false. I mean, if he's claiming that you're walking around his house looking at the pound cake, and then there's video of you doing a double take on the pound cake, that video of you doing the double take on the pound cake seems very relevant to addressing this claim that it's supposed to be a false description, a false characterization, or Lieutenant Lickum Lisa disconnecting the surveillance. A video of that seems very relevant. Especially since your complaint involves his dissemination of the depiction. So it's not just, okay, let's look at the raw underlying surveillance footage. This complaint is specifically taking issue with the framing and how that surveillance footage was used and disseminated after being like edited and compiled in the manner it was compiled in through videos like Lemon Pound Cake. Like, the Lemon Pound Cake is famous. Yeah, like, do a still life painting. He should sell, like, prints of, like, paintings of the Lemon Pound Cake. You know? It's false. He doesn't even like lemon. Oh, man. Anyway, which he knew to be false in a malicious and intentional effort to damage plaintiff's reputation and cause them emotional pain, suffering, humiliation, and embarrassment. Examples of some of Foreman's false and defamatory statements about plaintiff are the following. So let's get to some statements. On or about March 18th, 2023, Foreman published an Instagram post that, among other things, stated that plaintiffs stole my money and were criminals camouflaged by law enforcement. Now, this is interesting because this would be a statement about an officer. It's not really a personal... It's not really a claim against an individual person. It's specifically this person who happens to be a cop who's working in their duty as a cop when they come into my house and I don't get this money back. And I don't know, I believe there might be context here where this is protected in a way. Like if this was claimed in something official in a complaint, I would imagine that there's some type of privilege over this. But I haven't followed the arguments on this. I've only been looking at it since last week and haven't looked too deeply. But this just seems like something might be reaching with this. Like I can't go in the chat and accuse Gwennon of being a thief. She stole my money. She's a robber. I can't accuse you of a crime and then say I have the right to do so. I mean, I have no proof that you stole anything from me, you know? So, but it seems like this is a little bit of different context than something like that would be. So, on or about January 24th, 2023, Foreman published an Instagram post that, among other things, called plaintiffs the white supremacists operating inside of the Adams County Sheriff's Department. Oh, this motion in limine is going to be fun to read. Because they're going to say something else should be excluded because it's not relevant. So pin this one. You can't it's defamatory to call us white supremacists. Pin that one. On or about April 6, 2023, Foreman published an Instagram post stating that Plaintiff Newland used to do hard drugs, snitched on all his friends, now he steals money from traffic stops, bogus raids, and from the Adams County Sheriff Evidence Room. On or about April 18th and 19th, and this one, I mean, I wonder where we're going to get these contexts. Used to do hard drugs, snitched on all his friends. Now he steals money from traffic stops. So these two, the hard drugs and snitched on all of his friends, maybe that's one where he's got to put something up and call a witness so he can say, upon information and belief, here's why that wasn't knowingly false or false at all when I said it. On or about April 18th and 19th, 2023, Foreman published Instagram posts stating that plaintiff Newland stole my money and that Brian Newland had stolen $400 out of the evidence money. In various posts on Instagram, Foreman clearly and unambiguously implies, with words and images, that plaintiff Lisa Phillips is biologically male, is trans, or is lesbian. Do you think that was clearly and unambiguously implying that someone was biologically male, or was it insulting? In various posts, Foreman states that a purpose of the search warrant was to permit the sheriff's department to, quote, kill me, and that the plaintiffs attempted to kill me in front of my kids and came to kill me in front of my children, and that plaintiffs constituted a hit squad to kill me in front of my kids. Well, show the footage of them barging in there with their guns. I think the video is very relevant. The above enumerated statements and others are false. They were known by Foreman to be false when he published them, or he made them with a reckless disregard as to their truth or falsity. The above enumerated false statements are injurious to the plaintiff's reputations. Defendants' above described actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of plaintiffs. As a result of defendants' actions, plaintiffs have been subjected to ridicule, even in the further performance of their official duties, by members of the public who have seen some of the defendants' above described postings. In some instances, it has made it more difficult and even more dangerous for plaintiffs to carry out their official duties because of comments made and attitudes expressed toward them by members of the public. So before we go on to paragraph 33, wasn't part of the nickname Miss? Oh, is this? Oh, this has to be OCR'd, right? Let's do, was it liquid 2Cs? I mean, he's using a derogatory word that's associated with females. Like, I just don't even think it's a logical argument to make. It just seems like an insult. But anyway. Let's see. As a further result of defendants' actions, plaintiffs have been subjected to threats, including death threats, by anonymous members of the public who have seen some of the defendants' above described postings and have suffered damage to their reputations. As a result of defendants' actions, plaintiffs have suffered damages, including all profits derived from and attributable to defendants' unauthorized use of plaintiffs' personas, and have suffered humiliation, ridicule, mental distress, embarrassment, and loss of reputation. Plaintiffs continue and will continue in the future to suffer damages unless defendants are enjoined from further violations of plaintiffs' rights. So count 1. These are the actual claims. Remember, this one has been dismissed. 1 and 2 have already been dismissed. So, violations of Ohio chapter, unauthorized use of individual's persona. So this has been denied. We'll look at that order granting the dismissal. But plaintiffs repeat the allegations above. Plaintiffs are each law enforcement officers in Adams County, Ohio, and their personas are known in that community and beyond, both as public servants and private citizens. Plaintiffs' personas are distinct and recognizable within Adams County and the surrounding area, and plaintiffs have built that distinct recognizability through years of public service and private activities, and exposure to the public, often at great risk to themselves. As such, the persona of each plaintiff has significant commercial value because of reputation, prestige, social standing, public interest, and other values of plaintiffs' recognizable personas add value to any product or service with which plaintiffs' personas are associated. I mean, you're putting yourself at great risk. Like, I want to know the underlying basis for this, what they represented to the court to get this warrant where they're alleging they were looking for evidence of kidnapping. Like, what was the basis of that? Because it's hard for me to imagine what would have been like a good faith application there. And that would mean they're putting themselves in that situation. So, defendants use the personas of the plaintiffs for commercial purposes. We're going to skip some of this stuff because we're going to keep going. Count 2, this is also dismissed. Invasion of privacy by misappropriation. So, with that, they're saying that in plaintiffs' In using plaintiffs' personas as alleged herein, defendants have appropriated for their own use and benefit the reputation, prestige, that's to be disputed, social standing, public interest, and other values of plaintiffs' names and likeness, which have intrinsic value in contravention of plaintiffs' right to privacy. We've got count 3. So the remaining counts are still on the table. So count 3, invasion of privacy, false light publicity, restatement. We've got plaintiffs repeat all of the above. In their depictions and descriptions of plaintiffs on social media postings and elsewhere, defendants made statements that were false, and they knew to be false, and which portrayed plaintiffs in a false light, subjecting them to reputational injury, undue ridicule, embarrassment, mental distress, and anger. So if some of these issues are like, hey, you're comparing me, you're doing side-by-sides in these videos, you're showing the video footage of me in the house, you're claiming that we did improper things in your house, and that's all false. You have us next to Peter Griffin, you're putting Peter Griffin's on the video. That material is relevant. It seems like it should be relevant to you. If you think those things are in violation of each of these respective statutes that you're filing these claims under, then it should be relevant to you. Not only is it something that would be relevant for the opposing party to point to and be like, well, no, actually, look at it this way. This is showing exactly what I'm saying to be true as a defense. Like, I don't get the argument that these videos, particularly Lemon Pound Cake, are not relevant when they've explicitly complained about the comparison and calling the one officer Lemon Pound Cake. Like, the falsity is really that it was orange cake all along. Oh, man. A time. Crazy. So, plaintiffs repeat, so count 3, invasion of privacy, false light publicity. We went through that. They're going to say they want damages for it. Count 4, invasion of privacy, unreasonable publicity given to private lives. Some of defendants' postings, as described above, gave publicity to matters concerning the private lives of plaintiffs, which were not of legitimate concern to the public, and the exposure of which a reasonable person would find to be highly offensive. I mean, humiliating or offensive? For example, postings alluding to the alleged sexual orientation or gender identity of plaintiffs or the alleged criminality of family members of plaintiffs are not legitimate concern to the public. Criminality? Do you think criminality is not of concern, a legitimate concern to the public? That's a weird one, and would be highly offensive and objectionable to a reasonable person of ordinary sensibilities. I can picture the first part here being like inflammatory and somebody on the jury saying like, yeah, that was uncalled for or whatever. And then maybe debate, does it rise to the level of these claims though? Or was it just off the wall insult? That's two different ways to weigh that. But how do you just plainly say that someone saying, criminality of somebody, particularly someone that holds a position as a law enforcement officer, would not be of legitimate concern to the public? That proposition is highly offensive to me. So maybe I'm not a person of ordinary sensibilities. Defendant's actions were willful, all of that. Count 5 is defamation. Plaintiff repeats the allegations above. Many of the above enumerated statements published by defendants, specifically but not limited to those set forth in paragraph 28 above, are false. Just many of them, not all of them. They were known by the defendants at the time of their publication to be false and were published in spite of defendants' knowledge of their falsity or with reckless disregard as to their truth or falsity. So the idea that Afroman continued to make certain postings after the filing of the lawsuit, when someone was like, hey, this is defamatory, I'm filing a defamation lawsuit against you. That element, again, the facts still need to be weighed. But if the jury were to look at those things and say, well, we find these things to be defamatory, But we don't know. We find them to be false, but we don't know if he knew. If they see that those same things are being posted after notice of the first filing, then they'd be like, well, at that point he should know, and now we find that the elements were met. So, and I'm not saying that the jury is necessarily going to find that the statements themselves are false, but the continuing does give some meat on the bone, generally speaking. They say specifically defendant statements that plaintiffs stole money from Foreman, that plaintiffs threatened to kill Foreman, that plaintiffs threatened to kill Foreman in front of his children, that plaintiffs were sent as a hit squad for the purpose of killing Foreman, that plaintiffs are white supremacists, that plaintiffs are criminals, that plaintiff Newland used to do hard drugs, is a snitch, that he steals money from traffic stops and bogus raids, and stole $400 from Foreman, and that plaintiff Phillips is not female and is trans or lesbian, are all false statements. I mean, is that some of those statements? Where was that paragraph with the hit squad thing? Yeah. So their wording in the counts, their causes of action, that Afroman alleged they were making threats to kill. But that doesn't seem like the wording based on how this is described. In various posts, Foreman states that a purpose of the search warrant was to permit the sheriff's department to kill me. That doesn't say the sheriff's department was making threats or threatening to kill me. That's different. It would permit. It gave them a way to get in the door, and you never know what happens once they're in the door. And that the plaintiffs, quote, attempted to kill me in front of my kids. That's not alleging a threat. And came to kill me in front of my children. So, and that's an opinion, right? They came and they could have killed me while they were there. And that plaintiffs constituted a hit squad to kill me in front of my kids. Constituted kind of seems like together this is like that. So I think there's a opposite way to view these things that isn't the way that it's being described as listed in count 5 here. So these and other false statements about plaintiff were made and published by Foreman and other defendants with actual malice. Defendants knew that these statements were false, but made them anyway for the purpose of injuring plaintiffs. And then count 6, they want injunctive relief. They wanted him to stop, like earlier, and maybe for permanently. As described above, defendants continued to violate plaintiffs' rights, damaging their reputations, and subject them to undue ridicule. Is it undue? Mental distress and danger by posting untrue and demeaning depictions of them on social media and elsewhere. Unless defendants are restrained, plaintiffs will suffer irreparable injury to their reputations, their mental health, and their legally protected rights as defendants continue to willfully and maliciously violate those rights. I think the legally protected right that matters the most here is the First Amendment right to comment on the government and what the government is doing. So this is just so twisted to me. Hey, Freedom Ring, good to see you. Thanks for checking in. Hey, Keith over in Chicago. Good to see you. Man, this is... Whew. Anyway, they say unless they're restrained, unless Afroman and his co-defendants are restrained, plaintiffs will suffer irreparable injury to their reputations, their mental health, and their legally protected rights as defendants continue to willfully and maliciously violate those rights. The continuing injury to plaintiff outweighs any potential injury to defendants that would result from an injunction. The requested injunctive relief is not adverse to public interest. I disagree. I mean, maybe there's some scope here. But the request that you're asking for, the restraints that you're asking for, certainly seem to tip over commentary on law enforcement doing a search on a home and what they were doing while inside, like removing surveillance. That, to me, is something that I'm very interested in. I don't speak for the whole public, but plaintiffs have a substantial likelihood of success on the merits of their claims. Meanwhile, we know that 2 were dismissed. Plaintiffs should be preliminarily and permanently enjoined from continuing to violate plaintiffs' rights and from posing their personas for commercial purposes, posting false information and information that puts plaintiffs in a false light, and posting unreasonable private information about them. I don't really think, was there anything alleged above? And again, we didn't open all of the links, so maybe there's more specifics, but just because they link to something, if something was really identifying, like somebody was posting like, this is where my kids go to school, this is the time they get there. Like, we had one photo where faces were covered with emojis. So I'm not, like, was anything above really unreasonable private information being exposed? Who knows? Wherefore they demand judgment on count 1. They're looking for damages in excess of $25,000 in the amount of profits made by the defendant. You know, this was dismissed already. Count 2, damages in excess of $25,000, the amount of profits, that was dismissed. Count 3, against all defendants in excess of 25, because that's the jurisdictional amount. So they want punitive, they want compensatory damages, they want attorney's fees, and then they want a permanent injunction, enjoining all defendants from continuing to violate plaintiffs' rights and from publishing plaintiffs' personas for commercial purposes, publishing false information and information that puts plaintiffs in a false light, and publishing unreasonable private information about them, as to all counts for their costs, attorney's fees, and all other relief to which they may be entitled. And this is from Robert Klingler for plaintiffs. So there we go. And again, this was taking us back to 2023. This was filed May 9th. This came down, this order was October 10th, 2023. Decision and entry denying in part and granting in part defendant's motion to dismiss. So we're not going to read this entire thing, but let's get to, that's the procedural history. Defendants have filed 2 motions, motion to dismiss and strike. Let's see. This is important. So I wanted to just read the analysis, not go over the facts. All right, so here we are. The pertinent facts which have been alleged by the plaintiffs in this case are that they are peace officers who, while engaged in a search of the defendant Joseph Foreman's residence, were video recorded by Foreman and or others, and the video recording was subsequently publicized, along with commentary related to the video afterwards. The plaintiffs further allege that the use of their likeness was in connection with a place, product, merchandise, goods, services, or other commercial activities not expressly exempted under Chapter 2741 of the Revised Code. So a person is not required to have celebrity status to recover for statutory or common law appropriation. We've got a footnote here that just cites to Harvey v. Systems Effect from the 2nd District, 2020. However, the plaintiffs, who are local law enforcement officers, have related no facts to show that their names and or likenesses have any commercial value. And I get that this is like a literal, like it's like an analysis, a legal analysis, but it still feels like a burn. It still feels like a burn. Hey, Nick, good to see you. Good to see you. We just got done reading the more recent, the first amended complaint filed by the plaintiffs in the Afroman case, and we're breezing through the judge's order where he ends up dismissing count 1 and 2, and this is just fun. He says these cops have no commercial value. Oh man. Also, Adventure Aaron says it is absolutely adverse to public interest, considering that private citizens typically can't request injunctive relief from police officers or departments even after experiencing physical injury. Yep, this is all, it's just like, it's kind of perverse to see the way this is just being alleged. It's just like toppled on its head. Like, it's so funny because everybody says all the time, you know, First Amendment is meant to protect the public's right to speak about the government. Sometimes people will throw out First Amendment to justify a private citizen defaming another private citizen. And there is like allowable speech. You can't just penalize somebody. Even if someone says something that's false, they're still, did they correct it once they knew? Like you can't just financially ruin somebody or tie them up in litigation forever and ever and ever without it eventually becoming like, what is it called? Abusive litigation. Like there's issues here. And here we have government workers filing this as private citizens while also claiming that part of their value is because of their work as officers. And then they're also asking to silence someone's comments about them. Yes, malicious prosecution. There you go. I think I've talked too much about malicious prosecution lately. I'm losing my mind. It's just... So while they may be well known in their community and unquestionably are public servants who frequently come into contact with the public, this is not sufficient to demonstrate that there's any value in associating an item of commerce with any of their individual identities. In this regard, no facts have been suggested that this is a case similar, for comparison, to that of the well-known football coach and sports commentator Urban Meyer, who sued successfully for the use of his likely likeness in selling merchandise, capitalizing on his name to make money. In contrast to Urban Meyer's claim, it appears absent the plaintiffs demonstrating any particular commercial value, which has not been alleged in the plaintiff's complaint. Yeah, they didn't go and say, like, here's why I think my name is worth this much. That the defendant Foreman felt aggrieved by the execution of a search warrant at his house and chose to demonstrate his displeasure while at the same time selling his merchandise based on his own celebrity. Quite simply, the court finds there are no facts which have been set forth in the complaint which lend support to a viable claim for unauthorized use of individual's persona. The plaintiff has failed to state a sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. Furthermore, after presuming the truth of all material factual allegations in the complaint and all reasonable inferences therefrom in relator's favor, it appears beyond doubt that relators can prove no set of facts as to count 1 warranting relief. So that's the judge's findings on count 1 and why he dismissed. We've got, I will do EJF, will do. Count 2, invasion of privacy by misappropriation. So in count 2, the plaintiffs allege the following. In using plaintiffs' personas as alleged herein, defendants have appropriated for their own use, benefit, the reputation, prestige, social standing, public interest, and other values of plaintiffs' names and other likeness, which have intrinsic value in contravention of plaintiff's right to privacy. Defendant's actions were willful, all of that. So this section of the law says appropriation of name or likeness. One who appropriates to his own use or benefit the name or likeness of another is subject to liability to the other for invasion of his privacy. The comments in this section of the restatement are, A, the interest protected by the rule stated in this section is the interest of the individual in the exclusive use of his own identity, insofar as it is represented by his name or likeness, and insofar as the use may be of benefit to him or to others. Although the protection of his personal feelings against mental distress is an important factor leading to a recognition of the rule, the right created by it is in the nature of a property right, for the exercise of which an exclusive license may be given to a third person, which will entitle the licensee to maintain an action to protect it. How invaded? The common form of invasion of privacy under the rule here stated is the appropriation and use of the plaintiff's name or likeness to advertise the defendant's business or product, or for some similar commercial purpose. Apart from statute, however, the rule stated is not limited to commercial appropriation. It applies also when the defendant makes use of the plaintiff's name or likeness for his own purposes or benefit, even though the use is not a commercial one, and even though the benefit sought to be obtained is not a pecuniary one. Statutes in some states, however, have limited the liability to commercial uses of the name or likeness. So back to the argument in this ruling, a defendant is subject to liability or analysis. A defendant is subject to liability for invasion of privacy under Ohio law when he appropriates to his own use or benefit the name or likeness of another, and the name or likeness has commercial or other value. 23 footnote here says, this is from Wilson v. Ancestry.com. That sounds interesting. in relation to this type of argument. In this case, the value that seems to be at issue here is not the monetary value of they're going to say it's the feelings. He's going to say it's the feelings, isn't he? In this case, the value that seems to be at issue here is not the monetary value of the officer's likeness, which appears to be nominal. Another drag, another silent drag. Instead, the issue appears to be the humiliation and outrage. It's the feelings. This is hilarious. He's literally saying in the legal analysis here, the issue seems to be that they're butthurt. Oh, man. Let's read this. Let's just take in the beauty of this. This is a judge professionally calling someone butthurt. In this case, the value that seems to be at issue here is not the monetary value of the officer's likeness, which appears to be nominal. Instead, the issue appears to be the humiliation and outrage that the officers feel at having their likeness displayed and mocked by the defendant. Undoubtedly, they also feel aggrieved by their investigative actions being questioned publicly. Let's tell him, Judge. Tell him, Judge. Oh, I love this judge. This is the time. This is fun. People are so smart with the way that they word things and put them together. Like, this just seems so plain, but it's so spicy at the same time. Yeah, hey, Tony, good to see you. Yeah, their feelings is hurt. That's really what this paragraph spells out. I'm gonna have to add this to the clips in Discord, just as a memory. A very polite way to say someone is butthurt. Afroman case. I'll drop a link to the Discord in the chat in case anyone in the chat wants to join the Discord. We talk about a lot of like academic things in there too, but there's a little channel where we just drop like clips, memes, screenshots, just so we can go back and revisit them from time to time. So there we go. There's a Discord link in the chat. All right, so let's see. In this regard, while the parties might debate the artistic quality of the defendant's videos, music, and commentary, he's like, it might be crass, but oh well. It appears without question, that they were made as part and in the course of criticism and commentary by the defendant Foreman of the search and seizure that occurred at the defendant's residence. The court finds that plaintiffs have a minimal interest here in terms of their right of publicity. Certainly as public servants, the plaintiffs have to expect that they may from time to time be subject to commentary and criticism regarding their performance of their duties. After considering that commentary and criticism, as well as all of the facts contained in the complaint, the court finds as a matter of law that while their quality and appropriateness may be questioned, the defendant's artistic and musical renderings have substantial and creative content which outweighs any adverse effect on the plaintiffs in terms of their right of publicity. So finally, after balancing the societal and personal interests embodied in the First Amendment against the plaintiff's property rights, the court finds as a matter of law that the effect of limiting the plaintiff's right of publicity in this case is negligible and is significantly outweighed by society's interest in the freedom of artistic expression. So a win not just for public commentary, but also artistic expression. So Afroman's adding enough to it anyway. It's not just like a plain, I'm not just taking your face and putting it on a t-shirt and selling it. He's selling his commentary on your likeness. Accordingly, and why would you argue? Like, it's so interesting to have an argument where it's like, you're defaming me, but you're also using my likeness, and you could be infringing on my right to license. And yet we're not really arguing like, maybe because there's no trademark or copyright at play, and maybe that's what would get us there. But with trademark and copyright, you could get into things like, hey, this person's using our logo and it's confusing consumers because they're going to think that this is actually us, right? And maybe that's just not there because nothing's dealing with the trademark or copyright. Let's see, count 3. Remember these, from now on, the judge isn't going to dismiss any of these, but he's going to give us his analysis here. So count 3 was invasion of privacy, false light publicity. We've got, in count 3, the plaintiffs allege the following: that in their depictions and descriptions of plaintiffs on social media postings and elsewhere, defendants made statements that were false. This is over in Ohio. Right? Is it Adams County? Adams County, Ohio. We've got, they're posting these things that they knew to be false. They portrayed plaintiffs in a false light, subjecting them to reputational injury, undue ridicule, embarrassment, mental distress, and danger. The false light to which defendants place plaintiff would be highly offensive to a reasonable person, and so forth. So let's see. 652E states, one who gives publicity to a matter concerning another that places the other before the public in a false light is subject to liability to the other for invasion of his privacy if A, the false light in which the other person was placed would be highly offensive to a reasonable person, and B, the actor had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. Comments to Section 652E state nature of selection. The form of invasion of privacy covered by the rule stated in this section does not depend upon making public any facts concerning the private life of the individual. On the contrary, it is essential to the rule stated in this section that the matter published concerning the plaintiff is not true. The rule stated here is, however, limited to the situation in which the plaintiff is given publicity, on what constitutes publicity, and the publicity of application to a simple disclosure. See Section D, Comment A, which is applicable to the rule stated here. Relation to defamation. The interest protected by this section is the interest of the individual in not being made to appear before the public in an objectionable false light or false position, or in other words, otherwise than as he is. Well, if you're standing in the kitchen looking at pound cake, is that exposing you to a false light? So we've got, in many cases to which the rule stated here applies, the publicity given to the plaintiff is defamatory, so that he would have an action or liable. Hold on, I'm going to pause because I think Adventure Aaron just got my missing piece, as you usually do. You just filled in the gap, like I couldn't conceptualize it. Afroman created songs and music videos from footage he owned or were publicly available, so either it's his property, it's his footage, or if it's publicly available, it's not something somebody can slap a copyright on. And then put stills from the videos that he created on t-shirts and sold them, which had some like expressive additives, which then become transformative work. So, and I don't think he sought like a copyright or anything like that for his individual artwork, but that's why we don't see a claim, like there's no ownership over property of the materials at issue here. So we've got, and yes, Nick Star with a reminder to hit the thumbs up, folks. I like a nice lemon bundt cake sitting on the table, and hit that button. Don't just look at it, hit that button. We've got this relation to defamation. Sorry, I stopped in the middle. The interest protected by this section is the interest of the individual in not being made to appear before the public in any objectionable false light or false position, or in other words, otherwise than as he is. In many cases to which the rule stated applies here, the publicity given to the plaintiff is defamatory, so that he would have an action for libel or slander under the rule stated in Chapter 24. In such a case, the action for invasion of privacy will afford an alternative or additional remedy, and the plaintiff can proceed upon either theory or both, although he can have but one recovery for a single instance of publicity. It is not, however, necessary to the action for invasion of privacy that the plaintiff be defamed. It is enough that he is given unreasonable and highly objectionable publicity that attributes to him characteristics, conduct, or beliefs that are false, and so is placed before the public in a false position. When this is the case, and the matter attributed to the plaintiff is not defamatory, the rule here stated affords a different remedy not available in an action for defamation. Cool, so it seems like the element missing here, like you can have these things running in parallel, but it seems like here that you don't have to satisfy all of the elements that would be required for defamation, like the knowingly, the reckless disregard. It's like if you're doing something so horrible and it's so humiliating, so offensive, you could be held liable even if you don't know that it's false and do it with reckless disregard. So I think that's the distinguishing factor between this and defamation as a plain claim. So that's cool. I never thought about something like that before. I always love learning this stuff. So it is not, however, let's see, we're on C, the next one, highly offensive to a reasonable person. The rule stated in this section applies only when the publicity given to the plaintiff has placed him in a false light before the public of a kind that would be highly offensive to a reasonable person. In other words, it applies only when the defendant knows that the plaintiff, as a reasonable man, would be justified in the eyes of the community in feeling seriously offended and aggrieved by the publicity. Complete and perfect accuracy in published reports concerning any individual is seldom attainable by any reasonable effort, and most minor errors, such as wrong address for his home, or a mistake in the date when he entered his employment, or similar unimportant details of his career. Well, Shannon Burgess might be a different example here. He might be an outlier for something like this. Would not, in the absence of special circumstances, give any serious offense to a reasonable person. The plaintiff's privacy is not invaded when the unimportant false statements are made, even when they are made deliberately. It is only when there is such a major misrepresentation of his character, history, activities, or beliefs that serious offense may reasonably be expected to be taken by a reasonable man in his position that there is a cause of action for invasion of privacy. This actually seems like a cool thing to argue and dispute. Let's see. Next, we have constitutional restrictions on action. The free speech and free press provisions of the First Amendment have been held to apply to the common law of defamation and to impose certain restrictions on the availability of defamation actions. So, of course, the case that's always cited when we talk about defamation, New York Times Co. v. Sullivan, 1964. It was held that a public official could not recover for a false and defamatory publication unless he proved by clear and convincing evidence that the defendant had knowledge of the falsity of the statement or acted in reckless disregard of its truth or falsity. This rule was later extended to public figures. In the case of Time Inc. v. Hill, 1967, involving a magazine pictorial treatment of a play based upon a real episode, which implied that certain fictitious incidents in the play transpired with the real-life parties. The Supreme Court held that the rule of New York Times Co. v. Sullivan, we're going to just say New York Times v. Sullivan because that co is tripping me up, also applies to the false light cases covered by the section. It is on the basis of Time v. Hill that Clause B has been set forth. The full extent of the authority of this case, however, is presently in some doubt. Although the Supreme Court had extended the rule of New York Times v. Sullivan in defamation cases beyond public officials and public figures to all matters of public or general interest, by a plurality opinion in Rosenblum v. Retromedia, this position was subsequently repudiated in Gertz v. Robert Welsh, which restricted the knowledge or reckless disregard rule again to public officials and public figures, but held that in other cases the plaintiffs must show that the defendant was at fault, at least to the extent of being negligent regarding the truth or falsity of the statement. The effect of the Gertz decision upon the holding in Time Inc. v. Hill has thus been left in a state of uncertainty. Well, what's kind of interesting here is in their own pleadings, because they wanted to state the claims necessary, allege the facts necessary for claims 1 and 2, it's the plaintiffs themselves asserting themselves to be public figures. Like, they're not contesting, they're not making an argument that, hey, this is creeping out of the realm of us acting within our capacity as a public servant, as law enforcement officers, and creeping over into, private citizen territory. They're embracing the public figure role, at least for the purposes of the other counts in this complaint. So even if there's a restriction here from, I don't know if they're going to continue, maybe I should keep reading, but if this is presently constrained to knowledge or reckless disregard rule, it's restricted to public officials and public figures. Well, the plaintiffs were already asserting in pleadings that they are those things. So the restriction, they're not outside that restriction. Maybe that's changed since, though. They say the effect of the Gertz decision upon the holding in Time Inc. v. Hill has thus been left in a state of uncertainty. In Cantrell v. Forest City Pub, in our publishing company, 1974, the court found that the defendant was shown to have acted in reckless disregard as to the truth or falsity of the statement, and it consciously abstained from indicating the present authority of Time v. Hill. Pending further enlightenment from the Supreme Court, therefore, this section provides that liability for invasion of privacy for placing the plaintiff in a false light may exist if the defendant acted with knowledge of the falsity of the statement or in reckless disregard as to truth or falsity. The caveat leaves open this question of whether there may be liability based on a showing of negligence as to truth or falsity. If Time v. Hill is modified along the lines of Gertz v. Robert Welsh, then the reckless disregard rule would apparently apply if the plaintiff is a public official or public figure, and the negligence rule will apply to other plaintiffs. If Time v. Hill remains in full force and effect because the injury is not so serious when the statement is not defamatory, the black letter provision will be fully controlling. So I think this will come down to maybe like the splitting of the issues here. So when it comes to the claims of the officer who, like, if the claims of the drug use, the guy who said it was like hardcore drugs or whatever, if those claims relate to his use as a private individual rather than any public figure capacity, and then the claims of Lieutenant Lisa Lickham, if you look at those individual claims, if you find them to be statements as if they're meant to be true but they're actually false, I think there's a whole layer of issue with claiming that what seems like an insult that's not meant as a statement of truth about the gender of Lisa Lickham. If we get past that and accept that on its face, and then we say, all right, well, is there reckless disregard that we have to look for, or is negligence enough? Because that type of statement, it doesn't seem like you're necessarily looking at that individual just within their role of their duties, right? That could be something that you're now commenting on all around their existence as a human being, as a private individual, right? So maybe those two aspects would be the interesting items to look at for this count 3. James says, sorry I'm late because I got high. Carbon says, same. Love to see the unity in the chat. Love to see it. Oh, man. Okay, and then Creed says this is why they were saying with knowledge of falsity or with reckless disregard in their amended complaint. And I think that'll come down to, so jury instructions, like maybe the judge would make, well, maybe not, because I feel like it could still be left up to the jury. Like, I feel like the jury form's going to have to get very specific with the item numbers, the actionable items. Like, with this commentary about using the hardcore drugs, do you find that this comment was made reflecting so-and-so as a private citizen? Or I don't know the exact language that it would be in, but they kind of like got to funnel it down. And if you find private citizen, then it would have to go to the appropriate standard. If they find public, then it would have to go with reckless disregard, right? They're going to have to like choose your own adventure, the verdict form for some of these items, I would imagine. That sounds like a nightmare. That sounds like a fun time, those jury charges. So, okay, and you mean more, Creed was actually referencing they're claiming they're public figures. And I don't know, I mean, maybe there's still some room on these specific claims, those specific items. Like, sure, we're generally saying for the use of our likeness from the surveillance footage that we're XYZ, but those two particular sets of statements, the insults about the gender and the low voice, and then guy was using hard drugs or whatever, maybe there's an analysis there that would be argued in front of the jury, and the jury would have to decide, was this said about this person under the framework that they're a public figure, or more generally as a private citizen? So I think it would have to branch. So I don't know. I think it would have to branch per item, per actionable item. And the rest, the other things, would probably, the judge would already narrow down and not have that choose your own adventure branching on the other items. Like, on these comments of them while they're executing the search warrant on the home while in uniform, like, they're not going to have to make that decision because it should already be in the public figure bucket, if that makes sense. Cool. So, yeah, I think this would be, I agree with this. It doesn't go, if it, that makes the jury form easier. I don't think I've seen a decision on that. So I'll have to keep looking at the docket. But maybe that's not something that would be, unless I didn't look at the right name, I didn't see any orders that seem to have this type of discussion in the title. But I'll have to look again. So anyway, we've got application of defamation restrictions in this section. In addition to the constitutional questions discussed in Comment E, another important question is that of the extent to which common law and statutory restrictions and limitations that have grown up around the action for defamation are equally applicable when the action is one for invasion of privacy by publicity given to falsehoods concerning the plaintiff. These restrictions include, for example, the requirement that special damages be pleaded and proved by the plaintiff in any case in which the defamatory words are not actionable per se. They may include also the limitations imposed by retraction statutes, or statutes requiring the filing of a bond for costs in order to maintain a defamation action, as well as other possible restrictions. When the false publicity is also defamatory, so that either action can be maintained by the plaintiff. It is arguable that limitations of longstanding that have been found desirable for the action for defamation should not be successfully evaded by proceeding upon a different theory of later origin, in the development of which the attention of the courts has not been directed to limitations. And yet there is little authority on this issue. The answers obviously turn up the nature of the particular restrictive rule, the language of a particular statute, and the circumstances of the case, and no generalization can be made. And then damages. And damages recoverable and whether suit can be maintained without proof of actual injury. They say go to 652H, and that's where the judge's cites end here. So, well, I agree, James Phipps. He's a public employee performing his duties. He's not a private anything. But I don't know. I don't feel like the public figure isn't necessarily due to celebrity. It's due to the role as a peace officer, right? At least that's kind of like the way I saw the judge weighing it in the counts 1 and 2. So, and again, I mean, I agree. I mean, they're the ones claiming themselves to be public figures as if they have like celebrity type value. So I would hold that against them. So, like, you pleaded it yourself. But, in a way, I also don't feel like those comments were about somebody. I feel like there's commentary, and I'm not saying that I think it should go that way. I'm saying I could imagine an attorney trying to argue that those specific sets of items cannot be commentary on somebody in the course of their duty doing XYZ. It's just like a general statement about their being, their state of being. So, and we've got, let's see, the Ohio Supreme Court has recognized publicity that unreasonably places the other in a false light before the public as one of the 4 separate branches of tortious invasion of privacy. And a footnote here to Welling v. Winefield. There are certain requirements for a false light claim. First, in a false light claim, the statement which is the basis of the claim must be untrue. And it's the same case, Welling v. Winefield. Secondly, it must be publicized, which is different than published. Publication, in that sense, is a word of art, which includes any communication by the defendant to a third person. Publicity, on the other hand, means that the matter is made public by communicating it to the public at large, or to so many persons that the matter must be regarded as substantially certain to become one of public knowledge. The difference is not one of the means of communication, which may be oral, written, or any other means. It is one of a communication that reaches, or is sure to reach, the public. And that's also the same case. I think all the next footnotes are the same case. Next, the misrepresentation made must be serious enough to be highly offensive to a reasonable person. In this regard, and I'll tell you this, I'm not really one for like crass insults. It's just not my taste, but I don't think it's like highly offensive for someone to be like, dang, that person has a deep voice. Like, it's still, so I keep going back to that one example. I know that's not the only thing at issue here. But it's just one that just is not directly a commentary on, here are these officers doing thing while searching my house. So we've got next, the misrepresentation made must be serious enough to be highly offensive to the reasonable person. In this regard, the rule stated in this section applies only when the publicity given to the plaintiff has placed him in a false light before the public. Like, I don't think, hey, that person's got a low voice, are you sure? To me, that's not placing someone in a false light. I think the most contentious thing is going to be the claims that somebody was doing hard drugs. That's going to be the most contentious action item of this entire complaint. Of a kind that would be highly offensive to a reasonable person. In other words, and I would argue, if they have to end up arguing public versus private, I would argue that that claim is more important through the lens of a public official possibly engaging in this behavior. So that type of behavior in your off time is something that's necessary to consider for your role as a public official. So we get back to that lens regardless. But I'm not a lawyer. This is just me with my layperson way of thinking about something, saying, yeah, not literally everything I don't need to know when a police officer wakes up and brushes their teeth in the morning. Like, that's not really relevant to their work as an officer. Just stay away from me when you speak to me. But if they're doing drugs in their private time, quote unquote private time, I still feel like that's important. It's of public interest for me to know because of your job, if that makes sense. Just my layperson pontificating. We've got James says the point of the song video is criticizing, these particular government employees and their performance of their public duties. James also, so we've upgraded to Mel, I'm not a lawyer, but's way of, abbreviating, I'm not a lawyer, so we don't have to say IANAL, but INAL is the new way to do it. So it seems obvious to me, so I'm probably wrong about the ruling. No, it's just like, I think that's like that's just my gut feeling interpretation about it as well. And I think laws should kind of reflect what reasonable people gut feelings. Sometimes laws have to exist because there are gray areas. We've got to, carve things out a little bit more with some nuance, so we can figure out what to do when reasonable minds can differ. But yeah. So, but yeah, obviously anything that's a commentary on the video or is included in this video footage, it all seems to relate back to these officers doing something in their capacity as a public officer. So, upgrading my style guide now. Yep, INAL. And Creed says the public figure does not equal public interest, so the analysis for the count 1 and 2 is not applicable to analysis for the defamation actual malice standard. But that seems like someone being public figure and being spoken about is one thing, and then public interest is another. But I still think this count 3, those paragraphs that we were reading from count 3 were just kind of interestingly nuanced, wherever that relation to defamation was. I thought this was a cool little couched sort of in the middle, somewhat overlapping, but distinguished by this way. It was just cool. I've never had to think about that distinction before. So it's been really cool to think about. I don't know where I was. Publication must be offensive to the reasonable person. The rule stated in this section applies only when the publicity given to the plaintiff has placed him in a false light before the public, of a kind that would be highly offensive to a reasonable person. In other words, it applies only when the defendant knows that the plaintiff, as a reasonable man, would be justified in the eyes of the community in feeling seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when the unimportant false statements are made, even when they are made deliberately. It is only when there is such a major misrepresentation of his character, history, activities, or beliefs that serious offenses may be reasonably expected to be taken by a reasonable man in his position, that there is a cause of action for invasion of privacy. The restatement also accounts for multiple claims. Okay, so this is cool. Multiple claims arising under the same set of facts. The interest protected by this section is the interest of the individual in not being made to appear before the public in an objectionable false light or false position, or, in other words, otherwise than as he is. In many cases to which the rule stated applies here, the publicity given to the plaintiff is defamatory so that he would have an action for libel or slander. In such a case, the action for invasion of privacy will afford an alternative or additional remedy, and the plaintiff can proceed upon either theory or both, although he can have but one recovery for a single instance of publicity. Is that still the same case? Yep. First Amendment concerns are addressed by following the restatement standard, requiring that the defendant had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed, in cases of both private and public figures. Same case again, right? There we go. That case is doing a lot of work here. In construing the allegations of the complaint in the plaintiff's favor, as the court must do in considering a motion to dismiss for failure to state a claim for relief, the plaintiffs allege the following: that the plaintiffs stole the defendant's money and are criminals. They are white supremacists. One plaintiff used, quote, hard drugs and steals money from traffic stops and bogus raids from the sheriff's property room. I think this is important to pin again. I don't know. I can't tell, based on the names of witnesses, what witnesses might be called to discuss any of these things, all of these things, maybe none of these things. But there is one exhibit that seems to specifically be relating to white supremacy. So when you have a judge saying, look, here are specific claims for relief, these are the allegations, they are white supremacists, and then we're going to have a motion in limine where the plaintiff says, hey, this thing that's about white supremacy, I don't know the specific context of it, but it's something, some poster or something, I don't know the background, that they want to introduce to show. And I'm curious where it was found, right? I don't know the context, but it seems relevant. And right, and then it would become a probative value type issue. Is there a foundation issue? Maybe it's like we got it from a friend who's not named in this party, so maybe it doesn't directly apply to the plaintiffs here. But if it's sourced back to one of the plaintiffs, and it's something about the KKK, I don't know how well a motion in limine is going to go about that. And we still don't have a ruling. We'll probably get that ruling on the eve of the trial. So, let's see. We've got the plaintiff stole the defendant's money and are criminals or white supremacists. One plaintiff used, quote, hard drugs and steals money from traffic stops and bogus raids and from the sheriff's property room. One plaintiff stole $400 of the money placed into evidence. One plaintiff is biologically male, is trans, or is lesbian. The purpose of the sheriff department was to kill Foreman. These are contradictory, aren't they? If you're saying it could be any of the three, that's not really making a conclusion. I guess maybe it's eliminating. Well, this isn't really eliminating the possibility of being a biological female necessarily. I don't know. I don't know why that one's sticking out to me so much, because to me it just plainly seemed like a crass insult. The type of thing that, I don't know. Not all types of jokes make me laugh. I don't know. But just to call it an assertion, a statement about somebody, just seems like a lot to me. The plaintiffs aver all of these things are untrue. The defendants are alleged to have publicized the things set forth above, and the publicity was of a type that would be highly offensive to a reasonable person. The plaintiffs are public figures, but it can reasonably be inferred that the defendants acted in... So there you go. The plaintiffs are public figures, but it can reasonably be inferred that the defendants acted in reckless disregard of the truth or falsity of the statements made. The fact that the things that were said may be defamatory and give rise to a claim for defamation does not affect the validity of the false light claim. The court finds that there is a triable issue in this case as to whether the defendants committed a false light violation, and the claim can go forward, at least in the stage in the proceedings. So there we go. So they're going to say somebody can reasonably infer it on these specific allegations that we listed out in the paragraph before. And I imagine they're going to line item some of those things, because they'd have to, some of them are only for certain plaintiffs. So that's going to be interesting. I think this might be the most interesting one to pay attention to. Count 4, invasion of privacy. Unreasonable publicity given to private lives. We've got we're going to speed through some of this. These are, again, postings alluding to the alleged orientation and gender. This claim for unreasonable publicity given to the plaintiff's private lives is brought under the publicity tort for invasion of privacy. In order for a plaintiff to state a claim for which relief can be granted under the publicity tort of invasion of privacy, there must be publicity, so the disclosure must be of a public nature, not private, like posted online. The facts disclosed must be those concerning the private life of an individual, not his public life. The matter publicized must be one which would be highly offensive and objectionable to a reasonable person of ordinary sensibilities. And the publication must have been made intentionally, not negligently, and the matter publicized must not be a legitimate concern to the public. So, there we go. That's from Killalea v. Sears Roebuck. What a throwback. I think we have a Sears near me, actually. I think they're still surviving over here. Let's see. The restatement presents a definition of the tort. This is section 652D, publicity given to private life. One who gives publicity to a matter concerning the private life of another is subject to liability to the other for invasion of his privacy if the matter publicized is of a kind that A, would be highly offensive to a reasonable person, and B, is not of legitimate concern to the public. And yeah, I would say, like, if you find that this statement about the sexual orientation is a statement, isn't just like a quip, right? It's meant to claim something as being true, and the reasonable person wouldn't take it as a joke, then is it of legitimate concern to the public? With these standards in mind, and in reviewing the plaintiff's allegations as set forth above, the court is unable to say that it appears beyond doubt from the complaint that a plaintiff can prove no set of facts entitling them to recovery under the publicity theory of invasion of privacy. And then count 5, the defamation. So, defamation occurs when a publication contains a false statement made with some degree of fault, reflecting injuriously on a person's reputation, or exposing a person to public hatred, contempt, ridicule, shame, or disgrace, or affecting a person adversely in his or her trade, business, or profession. To establish a claim for defamation, plaintiff must show. So here are the ands. A false statement of fact was made about the plaintiff. 2, the statement was defamatory. 3, the statement was published. 4, the plaintiff suffered injury as a proximate result of the publication. And 5, the defendant acted with the requisite degree of fault in publishing the statement. And they're citing here Lagrasso v. Frey. And we're going to say it's from the Cuyahoga district because that's a cool name. We're just going to say it. Publication for defamation purposes is a word of art, which includes any communication by the defendant to a third person. A statement is defamatory if it reflects injuriously on a person's reputation or exposes a person to public hatred, contempt, ridicule, shame, or disgrace, or affects a person adversely in his or her trade, business, or profession. So, let's see. In New York Times v. Sullivan, they dropped the co too. They don't have it there anymore. The United States Supreme Court held that a higher standard, actual malice, applies to actions brought by public officials against critics of their official conduct. Actual malice prohibits a public official from recovering any damages for defamatory falsehood unless he proves that the communication was made with knowledge that it was false or reckless disregard of whether it was false or not. So, yeah, Creed M, I think this is important to emphasize too. Sexual orientation also isn't per se defamatory. Like, I think it'd be unreasonable. I'm sure there's some people out there that might find any misstatement of somebody's orientation is highly offensive. But I don't think that's a reasonable way to walk around the world. I don't think most people, like, I have short hair. I remember distinctly this little kid coming up to me at a Target, and they were asking me a question, and they were like, "Excuse me, sir," and it's because I was like facing whatever, so they only saw the back of my head with the short haircut. And as soon as I turned around, they're like, "Oh, I'm sorry, ma'am, I like your haircut." And like, I distinctly remember that they had that moment of realization, and the hair must have been on their mind because as soon as they realized, they also added in a comment about the haircut, and a nice one, right? They're like, I like your haircut. And like, come on. Do I think that person intentionally, do I think that little kid was intending to do something injurious to me? Like, come on. So, the idea of getting someone mixed up, even like earnestly believing and saying, go talk to that man over there. Like, and I get that the commentary is a little bit more than that. But I still think it was a joke. I think pretty plainly to me, it seems like a joke. But I do like the realization more broadly that, I don't know. I just don't think that we should consider something like this defamatory, because it kind of would imply, per se, defamatory per se, that it's inherently bad. It could be false, but to think it's defamation per se is different than just saying it's false. So, yeah. Oh, it made me laugh. I remember thinking, like, all right, don't like bust out laughing in front of this kid. Well, I don't really remember thinking that. I just feel like instinctively I must have just like kept it together. But when they walked away, I remember thinking like, oh my gosh, I hope they don't feel awkward. You ever have something like that happen? Like, I saw a TikTok or a reel where it was like a girl that sits in her car and she reviews food. And while she was sitting on the camera, the camera's like showing the person sitting in the car eating the food. Someone came and opened their passenger door thinking it was their own car. And it was like caught on camera. And the girl was like, oh my God. And the creator was like, wrong car, wrong car. And they're like, it's okay, it's okay, it's okay. And she commented after, like, I hope she didn't feel embarrassed because it happens. It's cool. Like, in my mind, I didn't want the kid to feel like it was the end of the world because they looked at the back of my head and said, sir. So, it was a time. It was a time. Let's see. We've got created by EJ. It was at Buc-ee's. It was, I think the girl was like parked at a gas pump and the other person was like walking back to what they thought was their car at the gas pump. And, certain cars, they just, some cars are very common. Same color, same paint. You could have the same car at Buc-ee's and you can get lost. That place is so big. So, just good times, good times. So let's see. Here we go. This is the important part and I'm distracted over here. So we just left off by saying the determination of whether a party is a private or public figure in a defamation action is a matter of law. There we go. So this is what Creed M has wanted me to get to. This includes the determination of whether a party is a limited purpose public figure. Police officers acting within the scope of their official capacity are public officials under Ohio's libel law, and therefore enjoy only limited protection from public discussion and criticism of their performance as public officials. Let me make sure these are all still the same. All right, so the last footnote was Holtree v. Weidman, and then we have Mueller v. Storer Communications. So we're getting some other cases in case anyone's interested in going deeper on Ohio's analysis. So accordingly, the officers in this case are classified as public officials for purposes of their claims of defamation. And I appreciate this because this is beyond, they can't wiggle out of this, right? This is the standard. This was my gut reaction. I think this should be the way this is weighed. But it's not like, oh, we're claiming to be public officials because we want to be entitled to this money and be able to say that somebody's exploiting us. This is different. This is a different way of saying somebody is a public official for this purpose. Statements made about public officials are constitutionally protected when the statements concern anything that may touch on an official's fitness for office. That's from Betsko, which cites Burns v. Rice. Let's see. Oh, quote, the abuse of a patrolman's office can have great potentiality for social harm, hence, public discussion and public criticism directed towards the performance of that office cannot constitutionally be inhibited by threat of prosecution under state libel laws. Additionally, under the standard enunciated in New York Times we got the back, v. Sullivan, a public official may not recover damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice, that is, with knowledge that it was false, or with reckless disregard of whether it was false. Additionally, proof of actual malice must be clear and convincing. And that's from Bedsco citing Gertz again. So the cases are interciting each other. The defendants argue that every statement made by them was a statement of opinion, which is protected under the First Amendment. The defendants are correct that expressions of opinion are generally accorded absolute immunity from liability under the First Amendment. In this regard, to be defamatory, a statement must be a statement of fact and not of opinion. The defendants maintain that there is no evidence of any false statements made by them. In contrast, the plaintiffs assert that the defendants made the following statements of fact and not opinion, which are false. 1, that the plaintiff stole money from Foreman. 2, that the plaintiffs threatened to kill Foreman. 3, that the plaintiffs threatened to kill Foreman in front of his children. 4, that the plaintiffs were sent as a hit squad for the purpose of killing Foreman. 5, that the plaintiffs are white supremacists. 6, that the plaintiffs are criminals. 7, that the plaintiff Newland used to do hard drugs, is a snitch, and that he steals money from traffic stops and bogus raids, and that he stole $400 from Foreman. And that 8, that the plaintiff Phillips is not a female and is trans or lesbian. They further assert that each of these statements is patently false. In determining whether a statement is actionable as defamation, the court must consider the totality of the circumstances to ascertain whether a statement is opinion or fact. And this involves at least 4 factors. So first is the specific language used. Second is whether the statement is verifiable. Third is the general context of the statement. And fourth is the broader context in which the statement appeared. We have a quote, whether certain statements alleged to be defamatory or actionable or not is a matter for the court to decide as a matter of law. Specifically, the determination of whether an averred defamatory statement constitutes opinion or fact is a question of law properly within the court's purview. In this regard, a court must review the totality of the circumstances, consider the statement within its context rather than in isolation, and determine whether a reasonable person would interpret that statement as defamatory. The determination is very difficult to make on a motion to dismiss. Many of the statements referred to by plaintiffs appear to be exactly that, statements and not opinions. This court cannot conclude as a matter of law at this point in the proceedings that the statements made by the defendants were not made with actual malice. Furthermore, the court cannot find beyond reasonable doubt from the complaint that the plaintiff can prove no set of facts entitling them to recovery as to count 5. And then the injunctive relief. A preliminary injunction is a remedy. It is not a cause of action or a claim for relief. So they're like, why did you put this as in your... I thought that was confusing too, but I thought maybe as a non-lawyer, I was just missing something that lawyers do that doesn't make sense. But apparently that's not what you're supposed to do. So there's a individual paragraph here that reminds the parties a preliminary injunction is a remedy. It is not a cause of action or a claim for relief. We have a footnote that cites here to Premier Healthcare Services. So we need case law on this. The court will consider the plaintiff's request for injunctive relief if and when the plaintiff prevails on one or more of counts number 1 through 5. So they're not going to do it now. At that time, counsel may brief and argue the authority and appropriateness of the court ordering injunctive relief in the manner requested by the plaintiffs. So, summary and comments, the court finds that as to counts 1 and 2, it appears beyond doubt from the complaint that the plaintiffs can prove no set of facts entitling them to a recovery, and a judgment of dismissal shall be entered on those counts. The court finds that as to each of counts 3, 4, and 5, it is unable to find at this stage of the proceedings that the plaintiffs can prove no set of facts entitling them to recovery, and the plaintiff's motion to dismiss as to these counts is overruled. The court would make several additional comments which hopefully will be of some assistance to counsel moving forward. In future pretrial and trial memoranda and briefs, each side needs to be specific in its arguments and memoranda. For instance, counsel should be specific in differentiating which statements that were made were opinions and which were statements of facts and the basis therefor. The same differentiation needs to be made between what is characterized as art, news, and accounts. It is so ordered. Oh, so this is a retired judge presiding over this. Is he still on right now? This is a couple years later. So there we go. That was the order dismissing counts 1 and 2. That was back in October of 2023. We're going to jump forward to March 2026, you guys. March 2026. And this is just quick. The defense, since trial's approaching, they file their proposed exhibits list for trial. Search warrant for the residence, return on the search warrant for the residence, policies and procedures for the Adams County Sheriff's Office, the music video, Will You Help Me Repair My Door, the music video, Lemon Pound Cake, deposition of Shawn Cooley. I would love to read those. Adams County Sheriff's Office body camera footage of the search of Mr. Foreman's residence, security footage of the execution of the search warrant for Mr. Foreman's residence, the Trinity White Knights flyer. So over in Discord, I was like, that's interesting. Deposition of Justin Cooley, deposition of like a bunch of the plaintiffs, any exhibit disclosed by the plaintiff in their case in chief, they want to be able to rely on themselves, any exhibit disclosed by the plaintiff discovery, and then the defendant reserves the right to supplement this list. So this was filed by David Osborne. And then we have what I'm going to call the punchline of the stream. So we've got March 12th, 2026, from the plaintiffs. Plaintiffs move the court for an order excluding irrelevant or unfairly prejudicial evidence, including evidence that relates exclusively to defendants' counterclaims, which the court has dismissed. So there were counterclaims filed that largely dealt with recovery for property damage, and those claims have been dismissed. If you want, we can look at that on a different stream, a part 2. Evidence that is irrelevant and that is likely to confuse the jury and cause undue delay at trial should be excluded. So 403s. The specific evidence to be excluded and the grounds supporting its exclusion are set forth in the accompanying memorandum in support. So let's see. And yeah, this is a different judge now up here, by the way. So it's Judge P. Hine. So here we go. Defendant Joseph Edgar Foreman's proposed exhibits for trial makes it clear that he intends to defend this case with irrelevant and sensational exhibits that attack and belittle the plaintiff deputy sheriffs who executed a legal and valid search warrant on his property. Defendant Foreman lists several exhibits that the court should exclude or limit the use of during trial because they are not relevant to any of the claims or defense in this case. A. So first up, we have the Will You Help Me Repair My Door and the Lemon Pound Cake music videos. The heading says, are not relevant, risk confusing the issues, and should be excluded. Hey Darth, good to see ya. Man. Defendant lists his Exhibit 4 music video, Will You Help Me Repair My Door, and Exhibit 5 music video, Lemon Pound Cake. These exhibits should be excluded because they are irrelevant to plaintiffs' claims and defendants' defenses to those claims. These music videos, posted by defendant on various social media platforms, depict plaintiff's execution of the search warrant at Mr. Foreman's residence and feature Mr. Foreman singing and rapping about the execution of the warrant, alleged damage to defendant's property, and the involved officers. Plaintiffs have not identified and do not intend to introduce either of these videos as evidence supporting their claims, probably because they look ridiculous, and they do not contain facts or information relevant to any defense against plaintiffs' defamation claims. They should be excluded as irrelevant evidence under Evidence Rule 401. And I gotta say this, even if some of the body cam from the search comes in, there's something different about the angle, seeing it like top down, looking at the group of officers rather than seeing the perspective of like the sort of point of view, like the chest area point of view of an individual officer walking around. So to me, I think it's different, even though it's recording the same point in time. In addition to being entirely irrelevant, introduction of these videos would create a substantial risk of confusing the issues for the jury. Confusing the issues for the jury. Defendant has sung, rapped, and posted on social media about plaintiffs dozens, if not hundreds of times since August 2022. All stemming back to his original art piece that went like largely viral. This Lemon Pound Cake video. So defendant has sung, rapped, and posted dozens, if not hundreds of times since August of 2022. Many of these videos, while offensive and disrespectful to the officers, do not contain defamatory or otherwise actionable content, nor do they contain evidence of the truth defendant's defamatory statements, or otherwise support or relate to any legitimate defense to those claims. Their introduction as evidence would only serve to confuse the jury about what is or what is not relevant to the case. The music video should be excluded pursuant to Evidence Rules 403A. The defendant's goal in introducing such evidence appears to be to create a circus atmosphere in the courtroom and to belittle plaintiffs' claims with videos disparaging their activities and demeaning their dignity as law enforcement officers and human beings. Because we've got to distinguish between the two. We've got to state both of them. Before we get into the Trinity White Knights flyer thing, yeah, Courage's just like, bro, you sued over those sensational exhibits. Like, literally over them. They are in the complaint. Oh, man. Where is it? Let's get this one going. James says sometimes the discovery process is worth getting sued. Just saying. Yeah, I mean, is this, like, I still want to know. Maybe they'll explain here where this came from. Yeah, Creedem says doesn't matter if it's different. If it tends to make the existence of a fact at issue more probable or not, it comes in. Also, his state of mind as to the statements is relevant. Well, I was thinking more like, you know, sometimes they'll argue like something's cumulative. There's something else that shows the same thing. It's repetitious. We don't need 100 angles of the exact same photo, but it's like slightly different. But I do think it's very different to see like what the whole group is doing rather than I can see the other two officers in front of me, but you can't see exactly what I'm looking at. Like Sergeant Lemon Cake's body cam footage video, if we took his body cam, we wouldn't see him eyeballing the lemon cake, which is part of the humiliation. So, it's so offensive you're saying I'm looking at this lemon pound cake. If we can't see that by looking at your own body cam footage, then the vantage point of the security footage obtained from the home, from Joseph Foreman's own devices, is really relevant. So, and you get that, but I'm just like opining because it annoys me. And I just got to get it off my chest. Oh, man. Yeah. And James offers the qualifier, suing the discovery benefit of it if you can afford it. Yeah. Otherwise, it sucks as much as if not more. So, Eve says, if the videos are excluded, what are we here for? What are we here for? What are we here for? Carbon says, that's what I said earlier. They did it to themselves, and now they lost and are just being retaliatory. Yeah, I don't know. So, I am Tetsuko. There was one thing I saw on the docket about media, but it was someone that was filing as if they were representing media, but they're an attorney from out of state, and they didn't have like admission to practice in front of this court. So whatever they were doing on behalf of whatever media outlet, it was stricken from the record. So it seems like somebody was trying to request some access, media access, but that's all supposed to be stricken from the record because whatever counsel representing them just didn't have the authority to make the motions to the court. So the attorney, not the underlying media party themselves. So, but yeah, James says, I can imagine the deposition. Officer, are you familiar with the Streisand effect? All right, so let's see what they say about this Trinity White Knights flyer. They say it's irrelevant and unfairly prejudicial. One of the defamatory claims, you're claiming that, they're alleging that we're white supremacists. So, it's irrelevant and unfairly prejudicial. So if it's not really related directly to any of these plaintiffs, we'll see where this argument goes. But irrelevant? So defendant lists as his Exhibit 9, Trinity White Knights flyer. This exhibit should be excluded. The flyer, there's no period there. The flyer is not probative of any fact of consequence in this. The flyer attaches Exhibit A, has not been referenced in any pleadings, depositions, or discovery in this case. Plaintiffs learned about this flyer for the first time when they received defendant's proposed list of exhibits. In addition to not having been identified before now, the exhibit should be excluded because there's no connection between it and any of the claims or defendants or any of the plaintiffs in this case. All right, so they're saying there's no connection. Is this flyer really attached? Sometimes it's not always. Oh. Geez, this is like an awkward. Is that where it starts? That's awful scanning. It says, arm yourselves, white citizens of Cincinnati. The Cincinnati police chief, Cincinnati mayor, Cincinnati city manager, and all 9 of the Cincinnati city council members, quote, will not help you against vicious attacks from those of color. Protect yourselves against these lawless thugs. Don't fall victims to senseless crimes. This is Americans on Guard, Trinity White Knights of the Ku Klux Klan. Yes, I wonder why they're saying that this has relevance. So, we'll have to look for a counter, like an opposition to this motion in limine. And even if there were some arguable, tenuous connection between this flyer and the issues or parties, any probative value is substantially outweighed by the danger of unfair prejudice or confusion of the issues or of misleading the jury. The flyer is unfairly prejudicial evidence that appeals to the jury's emotions rather than intellect. Let's see, the offensive and irrelevant exhibit is indicative of how Mr. Foreman apparently intends to, quote, defend against plaintiff's claims by casting them as a racist, white supremacist, Ku Klux Klan supporting law enforcement officers who were out to kill a black man when they executed their search warrant. This exhibit should be excluded, and the court should prohibit any reference or testimony about it or its contents. And if there's no opposition here, I can see this being granted. Like, if there's no opposition argument saying, well, here's the connection. Here's the connection. So the search warrant and return have limited relevance, and I mean, you're arguing that it was lawful to be there, and thus because it's lawful to be there, it's like humiliating that someone's covering you doing what you're there lawfully to do. But they say that their introduction should be accompanied by a limiting instruction to the jury. Defendant lists as his Exhibit 1, search warrant for the residence of Mr. Foreman, and as his Exhibit 2, return on the search warrant for the residence of Mr. Foreman. Plaintiffs do not object to the introduction of this evidence if its introduction is accompanied by a limiting instruction to the jury. All right. The warrant and return are only relevant to plaintiffs' claims or defendants' defenses as context explaining why plaintiffs were present, there you go, at Mr. Foreman's residence, and to establish that cash was seized from the residence. Defendants' counterclaims concerning the legality of the warrant, property allegedly damaged during its execution, and the sufficiency of supporting evidence for the warrant have been dismissed by the court and are not relevant to the remaining issues. Plaintiffs believe that defendant will attempt to relitigate his counterclaims and will attempt to introduce irrelevant and potentially prejudicial and confusing evidence by attacking the accuracy of the warrant affidavit and the way the warrant was executed by the plaintiffs. Upon the introduction of the search warrant and return, the court should instruct the jury that the warrant was legally valid, lawfully obtained, and lawfully executed, and that the contents of the warrant and the way it was executed are not issues for their consideration, except with respect to the cash seized during the execution. Well, that seems like a pickle, because it seems like some of the defamatory statements are on, like, improper things that were being done while the search warrant was being executed on. So, I don't know, it's kind of reminded me of Viverito and the Watch. Like, sure, maybe we can't bring a claim against Viverito or whoever, because I guess that's still up in the air or whatever. But, sure, we're not going to sit here and ask the jury to opine on an issue for the truth of the matter. Like, did they actually steal this cash and not return it? They seized it, and then they failed to return it when they returned the evidence. Well, but that is relevant to a claim because they're saying the one guy stole the $400 specifically, and then that's one of the defamatory, the actionable statements. Oh, what did I miss? Did YouTube get me? Sheriff Chuck coming in here for the rescue, gifting 5 gifted Cat Not Williams memberships. Thank you so much, Chuck. Sheriff Chuck's holding it down. He said, we're going to get through. We're going to get through this. J Money's also like half a year. Love me some Cat and Chat. We love you right back, J Money. Thank you for being a member for 6 months. James Phipps also becoming green. Are we on like a membership only restriction? No, they didn't tell me. It's probably because of that, let's see. Let me see if I open, if it tells me. Because I'm looking at StreamYard. Yeah, over on YouTube, I don't see anything. So, But thank you guys for the nice support. Appreciate you guys. And oh well, I mean, I don't know. Oh, it was the poster? Oh, okay, it did end me over on YouTube. All right, well, that sucks. Well, well, I'm gonna end this stream, you guys. Well, I guess for those on Twitter, I'll read for Twitter. Oh man, dang, they really got me for that flyer. I'm gonna say terms and conditions. That's crazy. Well, I'll have to re-upload this. Or now it's saying I'm back up. Can you guys see me? Now it's showing me live on my YouTube studio again. This is crazy. I'm sorry to everybody watching over on Twitter. Like, this is weird. It's still showing me that I'm live on YouTube. It just showed nothing was connected for a little bit there. Can you guys see me? Was I gone for you guys for like 5 minutes? Or maybe like 2 minutes? I don't know. Don't ask me to... Nobody saw me leave? I thought it ended my stream or something from the poster being on screen. Anyway. Anyway, glad to be confused with you guys. So, but it is weird. When I went over to my YouTube live stream panel, it said connect your encoder to go live. And then all of a sudden in the middle of me talking, my screen came back up on the YouTube studio. So it was blacked out on YouTube. It doesn't show me any of that on StreamYard. And I don't look at YouTube when I have StreamYard open. So who knows? Anyway, we are back. We are in business. We were like on this paragraph somewhere over here. Also, yeah, Sheriff Chucks, you've been here the whole time. Oh my goodness, you guys. In the future, I feel like you guys are going to troll me with that again. You're going to like, oh, the stream ended. And I'm going to fall for it all over again. So thank you. I am Shout also gifting 10 memberships in here. They're like, hold on, we're going to keep this party going. We're going to let Kat know that it's still here. And I started to see your chats on StreamYard. Even when I end a stream, there's like, I don't know, maybe like a minute where chats still come in. So after more than what seemed like 60 seconds went by and I still saw chats, I'm like, okay, well, something's wrong here. Maybe it's because we're still live on Twitter. Who knows? But major love here. I am Shout gifting the 10. Make sure if you just got a membership from I am Shout or Sheriff Chuck, show them some love. Show them some love. But yeah, James says, you know, it happens. It happened to Ian Runkle recently. I don't remember what that was that triggered it. I think it was a comment in the chat that people thought was the source of it. So, and it was like a joking comment, but I think that was the theory that chat triggered it. So who knows? Who knows what it could be? If that ever happens, you guys, what I think I would do is StreamYard should still save streams in the library, and I can always download the footage, try to fix whatever I think was wrong with it, and then put it back up. So, well, let's get into this. Let's finish this up. We've got the search warrant thing that we were talking about. Plaintiffs believe that defendant will attempt to relitigate his counterclaims and will attempt to introduce irrelevant and potentially prejudicial and confusing evidence by attacking the accuracy of the warrant affidavit, maybe because it'll presented claims of kidnapping, and the way the warrant was executed by the plaintiffs. That's the defamatory, what you're calling humiliating. Upon the introduction of the search warrant and return, the court should instruct the jury that the warrant was legally valid, lawfully obtained, and lawfully executed, and that the contents of the warrant and the way it was executed are not issues for their consideration, except with respect to the cash seized during the execution. We've got body camera and security footage have limited relevance. So they don't want the body camera introduced either? So they're not just trying to exclude... This is worse. I didn't know they were trying to exclude this too. I just assumed they want the pound cake video out because it has the commentary, it has the expression, it has the insinuations, and I thought that was problematic because it seems like their problem is the artistic expression that's put into that video, right? Which is part of their claims. But they also want the plain body camera and security footage excluded? What are we here for? How is he supposed to lodge his defense if you're complaining about things he said in relation to the search, but he can't show his video where he made artistic expressions or the body cam or the security footage? This is stupid. This is genuinely stupid. So they want that excluded. Their introduction should be accompanied by a limiting instruction. Okay, maybe they just want a limiting instruction. Defendants lists as his exhibit the sheriff's office body cam footage of the search of Mr. Foreman's residence, and as his exhibit 8, security footage of the execution of the search warrant at his residence. Plaintiffs, okay, they don't object to the introduction of the evidence. They don't object to it. They just want a limiting instruction. I was gonna lose it. I kind of did lose it. The footage is only relevant to Mr. Foreman's claims that plaintiffs stole money from him during the warrant execution. The footage is relevant to proving the falsity of Mr. Foreman's claims about plaintiffs, and its use should be limited to that purpose. So they only want that portion where that would be shown to come in. The court should exclude the footage. Never mind, they do want to exclude it. They just want to show the part where, oh, we're doing a thing right. The court should exclude the footage except for the portions relevant to the seizure and counting of money by Detective Newland. Plaintiff requests that upon introduction of the body camera footage and security camera footage, the court give a limiting instruction to the jury. Such instruction should inform the jurors that their consideration of the footage is limited to determining the truth or falsity of Mr. Foreman's statements that plaintiff stole money from his residence during the search. That's BS. You have other complaints about things that he said about this search. So he needs to be able to lodge a defense to them. And I don't know, I feel like I just ping-ponged. I went back and forth like, oh, they want this out? No, they don't. Only actually they do. This was me. This is stupid. This is so stupid. Yeah, basically we don't want any evidence entered in this case unless it might help us. I don't even see how this would fully help them. I don't really see how this would necessarily prove their claim that they didn't actually take any money. Because maybe the idea is this footage, it's not, they show the whole time that nothing's put away somewhere. But who's to say that that claim, that specific claim of money seized, or I guess they're trying to show counting. Are they going to have us watch really pixelated counting and show that it's the same amount that was claimed and then returned? Maybe that's what they'll do. I hope we get to watch the trial. So next we have policies and procedures for Adams County Sheriff's Office have limited relevance. So we don't want to admit policies and procedures. So the Sheriff's Office policies and procedures have limited relevance, and their introduction should be accompanied by a limiting instruction to the jury. Defendants list as his exhibit policies and procedures for the Adams County Sheriff's Office. Plaintiffs do not object to the introduction of this evidence so long as its introduction is accompanied by a limiting instruction to the jury. The only policy or procedure that is relevant to plaintiffs' claims relates to the seizure of the money during the execution of the search warrant. Any discussion of other policies or procedures would relate only to Mr. Foreman's already adjudicated counterclaims against plaintiffs. These policies are irrelevant to plaintiffs' claims and should be excluded. Plaintiff requests that, upon introduction of the policies and procedures, the court instructs the jurors that their consideration of the policies is limited to determining the truth or falsity of Mr. Foreman's statements that plaintiff stole money from his residence during the search. Then they want to get rid of the testimony of Rhonda Grooms, Natasha Purdon, Carly Patterson, Dorothy Chandler, and Tabitha Spires is irrelevant and should be excluded. These sound like wives or partners or family members of the plaintiffs. At least Grooms. There's Shawn Grooms as a plaintiff. Defendants list Rhonda Grooms, Natasha, Carly, Dorothy, and Tabitha as proposed witnesses for trial. These proposed witnesses are current and former romantic partners of plaintiffs. Plaintiffs object to their inclusion as witnesses because they have no information relevant to plaintiffs' claims or defendant's defense of those claims. Defendant did not disclose them as potential witnesses during discovery. Their testimony should be excluded under Evidence Rules 401. There we go. That's their motion in limine. I'll be looking for updates on that while we approach trial. Where was the case information? Let's see if it... No. I just wanted to verify that it said the 17th was the next day of interest. So let's see. We've got Foreman. Oh, I didn't do the CAPTCHA. I think the claim was like $400 was missing. So let's see. Oh, maybe this wasn't it. Maybe it was the docket entries that we want. Where did they note the trial dates? Ah, there we go. So, all right, yeah, there we go. So the jury trial dates, 4 dates here, the 17th through the 20th. So they're expecting it to last 4 days. Starting on the 17th. I swear I'd heard the 16th, but that must be, maybe they're not including jury selection here. So who knows? I don't know. Catbot, no caption needed. Oh my god, I'm so bad at those. Because I overthink everything. So when I get those, like, pick the ones that contain a crosswalk, I'm like, well, this one has like a tiny bit of ink showing from the crosswalk paint. So I should click that, right? And I click the ones that obviously have like a full crosswalk pictured. And then I submit, and then it tells me I'm wrong. So I'm like, okay, maybe I shouldn't have included that one that included a partial picture of the crosswalk. like, what's the threshold here? What's the Lugol's iodine testing that I should apply here when deciding whether or not a CAPTCHA image has enough of a thing pictured? The traffic lights, does it have to include all 3 lights? What about the ones where you see the poles, but you only see like the bottom of the light and you don't see the lights themselves? I get those wrong all the time too. Bikes. Do I click the motorcycles or just like the bicycles? Like which ones? Like they're so stupid. They all seem like trick questions. They all seem like trick questions. So there we are, you guys. That wraps up our deep dive on, the complaint and the motion in limine and everything in between. I still think it's very weird that they're requesting and saying these videos don't have relevance and that even the plain surveillance footage, like the pound cake video is supposed to be where these defamatory things are coming from. And we're invading the privacy because that's the high publicity thing. It's showing them in a false light. And then, of course, there's accompanying comments that were posted on social media. But a lot of that commentary on social media is relating back to the viral pound cake footage. And even using clips of that video, maybe not the video in its entirety, but clips of it for these different social posts. So it just blows my mind. Just blows my mind. Like, it's just stupid. So there you go, you guys. This stream was set to, and they should still be live unless they did a short stream. But the Fit Lawyer ATL and now Jay Witt podcast, who I used to call DWC, Dear Woke Christian. You might remember him if you don't know his channel separately. He has a huge channel. I didn't know he renamed to Jay Witt. But you might know him. We watched him. His last name's Whitaker. We watched him apply for his Rule 22 in the YSL trial. We saw him go up in there because he lives in Fulton County. He also did the ex parte transcripts reading with me. So it's been a while since he's been on this channel. So if you're new to me, you might not remember that. But that's who I mean when I say Jay Witt. I didn't know he renamed. And I feel really bad because I thought maybe he just wasn't doing content for a while until like a little bit ago when AV to the 7th Power said Jay Witt. And I was like, what? Wait. Pieced it together. And then I saw him pop up in my feed. He's doing a collab with the Fit Lawyer ATL, Miss Tiffany Adams. So this is gonna... You said wait? What am I waiting for? What am I waiting for? Oh yeah. The Ed Holly thing. Hold on. Yes. We've been following this case in Orange County, New York. We're calling it the Jurors Want to Google DNA trial. What? Yeah, they're on day today would have been day 10 of deliberations. Ben Nandy says the judge in Edward Holly's second murder trial says she's getting concerned about how long deliberations are taking. You ordered them to keep deliberating. So beginning Monday, she will keep the jury working at least an hour extra each day. We'll be entering week 3 of deliberations. For those who are just tuning in, Holly is accused of killing Megan in the town of Wallkill in 2003. Prosecutors say he was in the backseat Megan's car when he attacked Megan, who was in the driver's seat, and hit her in the head and face with a hammer more than 20 times as the fight moved outside the car. Let's see. I'll link to News 12 here if you guys want to jump over there. Let's see. And again, there was a first trial which ended in a mistrial because of a hung jury. The jury has since told the judge twice that they're deadlocked. Once just a few hours into the first days, and once this past Wednesday. So there we go, you guys. I don't like that. And I think the deadlock math was 5 for not guilty on Wednesday, I think. Maybe it was the first time. 5 for not guilty. 5 for guilty, 7 for not guilty. So, if they come back now and all do guilty, would it not be reasonable to be concerned that they just wanted to get out of there? Especially if you're going to make them stay late when they might not have been planning to stay late, that's an annoyance. And again, this is a second trial. So we'll have to see how this goes, but it doesn't really sit great. It doesn't sit well with me. So with that being said, Fit lawyer Jay Witt, their names rhyme, Jay Witt and Fit. They are going to be looking at body cam footage video. So sometimes those can be really aggravating to watch depending on which body cam videos they're watching. Sometimes they're a bit humorous and goofy. So we'll see. Hopefully it's a more humorous side of things. When I end this should redirect you over there. I guess it'd be smart for me to drop a link in case the redirect doesn't work. Let's see. And it's called Body Cam Friday, so maybe this will be an ongoing thing they do on Friday nights. So there is a link there. It's also in the Creator Friends playlist in the description of this video. Okay, and there is also, he has a mobile version streaming and I'm taking us to the desktop version. The chat is bigger there, so I'm going to send us all to the bigger chat version. He's got 2 streams going, so I think I'm sending us to the right one. So there we go. Let's see. So redirects aren't working on mobile? That's stupid. I don't know. Carbon says, are you going to be on tomorrow? Listen, I have an idea in mind. I think I have a song I'm going to ask for someone with some help making. And it's going to be the perfect parody song. I'm going to change one word. And it rhymes with the word that I'm changing. And it's relevant. You guys are going to love it. If it can happen. But every time I say, no, I got stuff to do, I end up doing a stream. So, I don't know. No promises in either direction. I wasn't going to go live today. And then I'm like, oh crap. It's Friday the 13th. It's the Jeff DeSantis testimony. It's Nathan Wade. And then I saw this motion in limine on the docket for the Afroman case. So I was like, here we go. Here we go. So there we go, you guys. Thanks so much for hanging out. Hope you guys are interested in continuing to follow this case with me. I'm looking forward to it. Interesting legal questions, even though the facts are so wishy-washy. It's cool to see the judge weigh in on well, these are public figures because they were doing police officer things. So even though they have no, what did he say? No value otherwise. No celebrity value. So there we go. Take care, everybody. Have a great weekend and hopefully see you over with Fit and Jay Witt. Yeah, appreciate your inability to resist us.